All right, everybody. So today I am here with Steve Lehto from Lehto's Law, and we are here to talk about right to repair. Many of you have wanted to see him on the show, so I'm happy, humbled, and honored that he decided to come on. So thank you so much. Can you introduce yourself
Thank
just for
you.
the audience of mine
Yeah,
that who doesn't know who you are?
I've got a channel on YouTube called Lehto's Law, and I've even got T-shirts, obviously. But I'm an attorney. I've been practicing law for 30 years in the state of Michigan, and I specialize in lemon law, which means I sue the car companies over defective cars. But the cool thing about that is that every single claim I file involving the lemon law also involves a count of the Magnuson-Moss Warranty Act. And the Magnuson-Moss Warranty Act is the federal statute that talks about warranties and what consumer rights are. So I'm intimately familiar with warranty law in particular, not just practicing law for 30 years. I taught law school for 10. The class I taught was consumer protection. We did a section on Magnuson-Moss. So on my channel, I talk about all kinds of consumer issues and legal issues and just stuff in the news. But occasionally we do talk about warranties, and right to repair has come up a lot lately. And I've talked about it a little bit, but it's not my specialty in that sense. But one of the things that intrigues me about it, and I love the fact that you're doing what you're doing, calling attention to this. Unfortunately, I think a lot of people misunderstand where the argument is and where it's and how it's been framed. And I've been trying to tell people lately that right to repair is not a radical idea. The idea that you've got to actually go speak to legislators and say, we want right to repair is kind of like saying we want a right of free speech. Technically, we have it, but what we need to do is we need to get it underscored or emphasized or clarified, because the big companies, the manufacturers, have managed to actually reframe the argument and make it look like right to repair is some kind of radical idea.
So there's a couple of things I wanted to unpack there, because a lot of people misunderstand what Magnuson-Moss is. So one of the things that somebody will say is they don't want right to repair. They want the ability to have the manufacturer cover it under warranty after they work on it. And I say, well, no, that's actually already been the law since the 70s. So if I take this phone and I put it in my toaster oven because the internet says that's going to fix it, the manufacturer does not have to cover that under warranty. All Magnuson-Moss says, to my understanding, and correct me if I'm wrong here, where I go wrong, is that the burden of proof is on the manufacturer to prove that I destroyed my device. So if I take my hard drive out of my computer and replace it, they can't say that's not the stock hard drive, no warranty for you. If I open the bottom of my machine and they see that my graphics chip, it's all brown around it and it's filled with flux and destroyed and components are knocked off, then they can say, you destroyed this, we're not covering it. So, and the second part that I wanted to go over there is where you said this is already the law. So that really, really did surprise me. Now, I know for automotive, right to repair in 2012 and then recently in 2020 to close a loophole just recently became law. But when you say that this is already on the books, can you explain that to me? Because I don't even understand that myself.
Yeah, and so here's the thing. The Magnuson-Moss Warranty Act is a federal statute. I printed out the two important sections here on my infamous blue paper. And so if you want to look this up, it's 15 U.S. Code 2304 or 15 U.S.C. 2310 are the two sections we're going to talk about. The Magnuson-Moss Warranty Act was passed in 1975, and it's the law that governs warranties that are given to consumers when they buy products, okay? And before Mag-Moss was passed, a company would put a product out and go, this has got a lifetime warranty. And you'd buy it, it would break, and you'd call them and say, I want it repaired. They go, oh, it's $100. And you go, for what? It's a warranty. They go, that's our warranty. So the federal government, Congress, passed this law to stop that kind of abuse and to basically make it uniform so everyone knew what they were getting when they got a warranty. So it starts by saying federal minimum standards for warranties. So all warranties in America, to abide by the law, must meet certain standards. And so the very first thing, for instance, in the very basic warranty concept is that a warrantor, which is a company that sells a product with a warranty, the warrantor must, to follow the law, as a minimum, remedy a defect within a reasonable time and without charge, and so on. And so if you bring them a product and go, look, it broke under warranty, they've got to remedy it within a reasonable amount of time, no charge to you. And so that everyone understands that concept. So that's very, very basic, but that's where this all starts. But then it says if they cannot repair it or replace it within a certain amount of time, then they must refund you your money, give you your money back, or replace it with another product that's not defective. And so, interestingly, a lot of people call this the federal lemon law because it does the same thing that most state lemon laws do. State lemon laws say your car is defective so many times in the shop, so many days in the shop, whatever. Within a time frame, they've got to either repair it, replace it, or give you your money back, okay? But the thing about the Mag-Moss is it doesn't apply to just cars. It's any consumer goods. So you say, okay, but Steve, we're all on this same page right now. Well, the problem that we have with right to repair is that manufacturers will say, we're not going to honor the warranty on your product because you did something to it you weren't supposed to do, right? So I love to tell the story about in the old days, the old VCRs that had the piece of tape on it, and it says, remove this tape, voids the warranty. Well, wait, that tape doesn't do anything. The tape is decorative. The tape is actually a violation of the law. And so, interestingly enough, the Mag-Moss has two sections that come into play when it comes to right to repair. One of which is it says that they don't have to cover something if it's abuse, misuse, or something like that. So you take your phone, put it in the microwave, and fry it. You can't bring it in and say, hey, it doesn't work anymore. It got fried in the microwave. That's abuse or misuse. But they also cannot, as a matter of law, require you to use particular parts or particular service unless they've done certain things. So in the old days, for instance, if you bought a car, General Motors would love you to use their oil, their spark plugs, their fan belts, and their service for everything on your car, including routine maintenance. And in the old days, companies would do that, but they're not allowed to do that anymore. Specifically, it says that, I'm talking about 15 U.S.C. 2304 sub B1, and it says specifically that they cannot force you to do that unless the warrantor has demonstrated in a rulemaking proceeding or can demonstrate in some kind of hearing that this duty is reasonable. So let's assume for a moment that you've got a cell phone, right? And you repair the cell phone by putting a different part in there, a battery, right? The battery went bad. You pull the old battery out, put a new battery in. But you didn't use their brand of battery. You just used a generic battery, but it works. Everything about it's the same. If they say you voided the warranty, the obligation, the onus is on them to prove that what you did is wrong. And so what that means is they cannot preemptively say that you've done anything wrong. They have to wait till you've done it. And then when you file your claim, they'd have to prove otherwise. And so what all of the companies are doing nowadays is telling people, oh, you've done that, you've voided your warranty, hoping that you'll go away, hoping that you won't sue them, hoping no class actions get filed. And in most cases, nobody does pursue it because it's too expensive to pursue over something like the battery in a phone.
Yeah, I agree with you on all of that. The only the one what's the word I'm looking for here? Devil's advocate argument I provide for the manufacturers, in some cases, it's really difficult to prove who did it. So, for instance, if you have a MacBook and you replace the battery, let's say you have an older A1278 model, they put the 12-volt power line right next to the 3-volt data line, and what most people do to pry this connector up because it's a pain in the ass and they don't have a pull tab is they use their screwdriver, and they go,
Right.
Now this flathead screwdriver is going to short the 12-volt power line to the 3-volt data line and fry your SMC. But how do you prove that the SMC, is the SMC defective, or did the user do that? The only way you're going to know that is if you can go back in time and watch what they did and see the spark. So I get where the manufacturer's coming from, which is if you opened it, we're just going to void your warranty. But at the same time, and maybe it kind of incentivizes them to not design things in a manner where it's this easy to break during the course of routine maintenance.
But your devil's advocate argument is already buying into the wrong frame of mind, because the law says that you, as the consumer, are obligated to show them that you've got a product that's defective under warranty. The burden is on them to then prove otherwise. So it's not your job to prove that you didn't damage it. It's their job to prove that you did. And that's the thing. There's actually case law on this. And I can get you a great example from the field of cars. There's a famous BMW case where a guy bought a BMW, drove it for a couple of years, the engine exploded, and he brought it into the dealership, and the dealership goes, yeah, we'd fix it, but BMW won't let us. And in trial, the judge said, all the consumer's got to show is that the engine blew up and he brought it in under warranty. It's up to BMW to prove that he did that through abuse, misuse, or some other fault of his own. And if they can't prove it, too bad, that's on them. So it's actually two burdens of proof. You prove you've got the product and the warranty and a failure, and then they've got to prove otherwise. And so when they talk about a specific example, like you walk into your phone and you go, look, it's got a problem. That's one thing. I'm talking about the broader topic where they say anybody who does this is voiding their warranty. We're going to make this blanket proclamation regarding our products across the entire world and universe of people who bought our products, right? When they make that proclamation, they are by definition violating the law, because the law says they can only do that after they've had an adjudicative or court hearing on the matter or some kind of administrative law hearing. And by the way, they could do that if they wanted to, but they don't bother doing it because it's easier just to make the proclamation and scare consumers.
I agree, and the thing there is that I agree that it should be on the manufacturer to prove it. At the same time, there are many cases like the one I brought up where it's not going to be possible for a manufacturer to prove that. I get a lot of items in where I can easily prove, you opened this after I gave it back to you, didn't it? And they're like, yeah, and I'm like, yeah, I could tell. But there's also things where it's just certain flaws where I would just never be able to tell. So I could see how that could be a nightmare to certain manufacturers that have a penchant for putting 52-volt power lines next to 1 or 3-volt data lines.
And it's going to vary wildly from product to product. What the issue, what the thing is. So the most obvious one, for instance, is where they said, if you slice the tape on this product, you void the warranty. What does slicing that tape have to do with anything?
Yeah, I'm surprised that they were able to get away with that for as long as they did, because when I was a kid, I used to see those stickers on my toys when I was 5 years old. So, I mean, this is not something that's recent. This is something that had been happening for a really long time.
Yeah.
Now, one of the things that you had mentioned to me is that this is not really a particularly radical notion, and here we've discussed, most of what we've discussed is warranty. One of the pieces that I'm discussing is something that some people on the, consider a radical notion, which is most of the products I work on are out of warranty. Someone spilled a beer on it. That no warranty. Your warranty is destroyed, and it's easily demonstrable by the way it smells and looks in the inside. And
right.
What the company will do is they will take an off-the-shelf charging chip from Intersil or Texas Instruments. They'll change one thing, like the address it communicates on, or something, or a handshake or something. They'll change like one stupid little thing that has nothing to do with most of the functionality of the chip, and then it will not be compatible with the other standard chip. And then they will tell the company, but don't sell this to anybody. Texas Instruments, don't sell. No, don't let DigiKey or Newark or Mouse or any of your distributors get this. If anybody contacts you and asks for this chip, don't sell it to them. And what I'm saying is that that's bullshit, and that should stop. That should end. And that's something that some people have said is really controversial. What right do I have to tell a company that they have to sell me a charging chip? And do you see this as a radical notion?
Well, that's more of an antitrust issue. And again, that's a different field than Magnuson-Moss, but if there's a company that sells a product, right, and if I enter into an exclusive agreement with you and I pay you extra money, I might be able to buy that exclusively from you in such a way that no one else can get their hands on it. But you'd have to take a really, really close look at that, because simply saying that I'm going to buy this from you and no one else can make these or build these or sell these, if it's not patented, then it might become an antitrust issue. But that, I'd have to take a closer look at that because it's outside of the field of warranty law.
Yeah, now the thing that's interesting here is I actually have retained an antitrust attorney to help me with bringing this to the attention of the FTC. There are some people coming into the FTC that are pro-right to repair, like Lena Khan, that
right.
Have written papers at length going over the ways at which they think that big tech have been screwing people over the past few years. And I want her welcome package to be, here's on a silver platter the things that you should be looking at. And one of the things that my antitrust attorney was saying is you could make the case as a tying claim, but you'd have to say that this particular company that's taking part in this has a lot of the market share. And my argument has been, Apple doesn't have all the. It's not like they have 50% of the market for these products.
Right.
My argument has been every company is doing this. So each one of these individual companies does not have all the market share, but in some way, shape, or form, every company does this. They do it in different ways. It'll be with a different chip or a different part, but it's not like I can knock on Dell's door and say, hey, I would like a schematic for this, or Compaq or HP or Acer or Asus. They all have some form of this. So, and that's the trouble that he's having with coming up with a way to argue the tying claim in this white paper.
Right.
Is there anything you'd have to add?
I hadn't actually thought that much about that one, and that's an interesting one. Also, the question is whether any of these companies are colluding with each other, because that's another interesting concept. Is that if the companies agreed to be non-competitive, that would be another potential problem there. But yeah, that's something that the antitrust attorney could probably take a closer look at.
Yeah, because I don't think it's a radical notion when when I grew up, every device that I used a AA, AAA, C, or D battery. Now, every
Yeah.
single device that we use uses a chargeable battery that is glued into it that you can't even remove.
Right.
So, the chip that controls charging or the chip that interfaces with the USB-C charger, these two things, these are the most common things to break in most modern devices. And the idea
Right.
that you could tell the company that makes it don't let anybody buy this is kind of insane to me. And when usually the argument people will have is, well, just don't buy Apple products. And it's, okay, cool. I don't buy Apple products. So show me a phone that does sell me a schematic. Almost every one. There's a different chip, a different part, a different piece, a different document for every different company. But you're not going to find a company that's going to do this. You don't really have a choice unless you simply want to live a 1960s, 70s lifestyle and have a phone that you do this to.
Well, and here's the thing is that this is actually all part of planned obsolescence in a roundabout way. And I remember in the old days when a car had all kinds of grease fittings on it to where you'd get an oil change and they'd also do a lube job on the car because they had to grease all these fittings. Somewhere in the 60s and 70s, a lot of cars, they started just not putting grease fittings in because, number one, it made the cars easier to maintain. Number two, the cars would wear out faster. And there were products that were clearly put in the market to last a certain amount of time, after which they hoped it would wear out or break, so you'd buy another product. And the interesting thing about cell phones is that cell phones often become obsolete because of changing technology. I mean, I remember the really cool flip phone I had, the StarTAC. That thing was cool, but it was so obsolete so fast that it didn't have to break. I threw it away because it got replaced with a BlackBerry. And so The interesting thing is how much of this is on there clearly just saying, hey, look, we're going to put a product out. We want them to buy another one in a year and a half. And if it breaks within a year and a half, who cares? They'll buy another one, And so it's in my mind, it's bad marketing and on the one hand, and whether it's illegal or not is another thing. But it's interesting the fact that they'd actually make each one just a little bit different enough and make it so you can't get the parts, because then that does actually create planned obsolescence without them ever actually calling it that.
Interesting. Yeah, because that's one of the main things that I have been pushing for now. Now, are there any things that you see with how right to repair is being worded or advocated for right now that you think would be a hang-up when it gets to a legislature, where one could say, we can't really pass this because this is in conflict with a different piece of federal law?
My concern is that the way the question's framed is that people think you're asking for a new law. And much of it is already on the books. It's been on the books since 1975. I mean, I don't know where you were in 75, but
Dead.
I know, or not alive yet. But the point is that what we want here, and by the way, the Federal Trade Commission is empowered to enforce the Magnuson-Moss Warranty Act. So the Federal Trade Commission ought to, and I say ought to because unfortunately it's a very political body. It depends on who's in the White House. But the Federal Trade Commission ought to enforce the Magnuson-Moss Warranty Act. And by that, I mean, when they see companies that are doing things that violate the act, they should step up and say, you guys are violating the act, and you may need to take steps. So you're right. The idea that the old VCRs had that piece of tape on it, they should have just come out with a new, because they're allowed to issue new rules to clarify the Mag-Moss Act. They should have come out with new rules and just said, you guys can't do that. If you do that again, it's going to be an automatic fine. And they should have fined them for doing it. They didn't do that. Nothing happened. And so the point here is that what we're looking to do instead is, instead of drafting new legislation and actually, because no one likes new legislation. It takes a lot of work. People got to sit down and write a law. Actually point it out and go, hey, look, we already have this right on some of these issues. It's already there. All we want is clarification and enforcement. Because here's the other thing that's going on here. Let's suppose that I've got this thing right here, whatever is the widget, and it's under warranty, and I bring it in, and I say, well, warranty repairs, and they go, well, we're not going to work on it because it looks like you opened this thing up at one point or another. Don't know what you did, but you opened it up, right? So they deny my claim. I can sue them under the Magnuson-Moss Warranty Act for damages. I can get my attorney fees and court costs paid, and I can also ask for equitable relief. But the problem is that most people, when they file a simple lawsuit over a single item like this, you file that, the company will almost always come in and go, you know something? It's not worth fighting this one thing. We'll pay you for it. So they go, what this thing cost you? $500, $1,000? We'll pay you for that. We'll give you a new one, and we'll pay your attorney $1,000 to make them go away. And so they'll do that on these individual cases, but they know that 99.9% of the people out there who are in that situation aren't going to know it's against the law, aren't going to pursue it if they did know it. And if they did pursue it, they're going to have a hard time getting anybody to even take the case. There's very few attorneys who know much about the Magnuson-Moss Act or who file these claims. But the interesting thing is, and this is food for thought, is that you can file a class action under the Magnuson-Moss Act, and you can also ask for equitable relief, meaning that if somebody has a good case on a product where they keep denying claims for a particular reason that we think is bogus, you could get an attorney to file the action as long as you got a good plaintiff, bring it as a class, and ask a federal judge to issue an injunction. And equitable relief would solve this problem real fast. But like I said, that's how you could fix some of this. But that would be a case-by-case basis against a particular manufacturer. And again, you'd need to have an attorney and a plaintiff who want to pursue this and have the time and the wherewithal to actually, take it on.
Damn. Yeah, I can imagine that, for every one person that gets an attorney, there's probably 1,000 people that just curse, leave the store, maybe leave a 1-star review, and then just get screwed.
And that's why I specialize in cars, because cars are a large enough product financially to where it makes sense to pursue it. I get calls all the time about things like dishwashers and vacuum cleaners and snowmobiles, and some of these things are so low in money. Maybe not a snowmobile, but a vacuum cleaner, where I could pursue it, we could win. And then I'm in court one day saying, Your Honor, I got him to buy back a $300 device, and I want $5,000 in attorney fees.
Yeah, it doesn't work.
You crazy?
That's a crazy part of the American system, and I completely understand and respect lawyers getting paid, but there are just so many areas where someone will tell me, you should sue, that's illegal, you should do this, and it's an attorney is $400 an hour, like on average here. You realize that, right? And it's not gonna it doesn't work out that way.
Right.
I don't. Now, is there any way that you think would be a good way to get across to a large number of people that don't know that this is an issue that it is? Because one of the things we found out from a poll in Massachusetts, I think, was something like 2% oppose right to repair, like 1 or 2% oppose, 45 to 47 support, 53% are like, what's that?
The best thing you can do is get a good example, okay? There's got to be, because I do a lot of lemon law cases. Whenever I'm interviewed by somebody who says, what's lemon law all about? I tell them, their eyes glaze over. And then I go, yeah, but I had a client once whose car, the engine exploded 7 times. 7 times in 2 years. And they're like, what? It's by the side of the road because his engine's smoking, there's oil pouring out from underneath it. Now suddenly it makes sense. So there's got to be some product that could be the poster child for right to repair. Something that you could fix, but technically you're not supposed to because it'll void the warranty. And I would find 1 or 2 examples of that and advertise how common this is, how it could affect you. Because there was a time when you asked people about right to repair and you go, what kinds of things are we talking about? And they couldn't come up with examples. And now I suspect a lot of it has to do with the way the technology works on smart devices, right? There's so much stuff there that could be repaired by skilled people, but who, a lot of people are scared, like, hey, if I break this thing open, I'm gonna void the warranty and get in some kind of trouble. They view it almost like the tag on their mattress, like, well, I go to prison for this,
Yeah.
So I would try to find that. I mean, aren't there some really good examples that you know of that affect a lot of people with some thing that you could fix that you're not allowed to?
Yeah, I have a bunch of examples, and I'm just at this point trying to figure out the way to get it across to people outside of just my YouTube audience. Because I'm glad that more people know what it is, but there's 320 million people in the country, 1.5 million subscribers. I got a long way to go.
Yeah, well, no, here's the deal. I'm a media whore, and by that I mean I have been on TV, I've been on radio, I've done newspaper, I've been quoted by the New York Times, the Wall Street Journal, I've been on the BBC. Anytime somebody points a camera at me and asks me to talk about what I do it because I'm trying to get the word out about consumer protection, lemon law, and all that stuff. And so I've discovered that when it comes to public relations, it's the stories that grab people. And so you want to get the 1 or 2 really good examples and say, hey, this could happen to you because it happened to this person I dealt with. And the second you let someone realize this could affect you and your pocketbook, they get real interested. Otherwise, to them, it's like watching something on TV. They don't even know if it's real or not,
Yeah, that's what I found. Thank you so much for taking the time to do this. I really appreciate it. I don't have any other questions. Is anything else you'd want to end the show on?
Well, the only other thing I was going to talk about is, and we didn't talk much about this, but there's the other issue with like the John Deere problem, right? And I've dealt with some clients who bought these products, like, extremely sophisticated tractors. And in the old days, a tractor was a really simple piece of equipment. There's an engine, some kind of transmission, two big wheels, two in the front, and it just, pushes dirt around. Nowadays, they've got all kinds of computerized devices, and so there's the problem with some guy who drops a ton of money on a tractor made by any one of a number of different companies, and he's not allowed to work on it because his fear is that if he does any work on it, even if he knows how to fix it, that if he brings it back in later for warranty repairs, and say, "Oh, you've tampered with it somehow," that voids the warranty, because there are some things on it that the dealership will say, if we don't do this work, it's going to void the warranty. And then the problem, of course, is that to do the work, they've got all kinds of proprietary equipment and codes and programs that John Deere provides to the dealerships, but nobody else. And that's another problem also, obviously. And, they're fighting that one right now. I know the manufacturers are, but I again, think that the reason they're getting away with it is that the people it affects most directly are farmers who bought these big tractors. And what portion of society are they? It's not that big of a portion. It's nowhere near as big as, like, say, the number of people who have smartphones or cars. So again, it's just bring more attention to the topic, shine a light on it, and try to explain it in plain English so that everyone understands how it can affect them.
That makes sense. That's something I got to get better at doing. Well, thank you so much for taking the time. I really appreciate it. It was good
Hey,
having you.
anytime, my friend. Anytime.